This is the Jay Pitt Show.
Last week, the Sitzer-Burnett settlement with National Association of Realtors was formally approved by the court holding jurisdiction over that case. I don't remember exactly what that court was, so I don't want to speak out of turn, but it was formally approved. We all know, and you may have seen, this may have been out of the news for a couple of months now, because on August 17th nationwide was the implementation date for the change of policies set forth by NAR as a result of the settlement. So you may have thought that this was gone away or that it was already approved. It wasn't, in fact. It was awaiting approval by the federal judge that oversaw the case. That was issued. News was made by the Department of Justice by issuing an opinion. It might have been like an amicus brief, which is, I think, technically a friend of the court kind of brief or ruling or opinion, which this is kind of all over my head as a legal, I'm not a legal analyst, I'm not an attorney, but essentially they weighed in and they made this opinion public where they essentially said that they don't necessarily agree with the terms of the settlement, and they put NAR on notice essentially in doing so that they may pursue them in the future for antitrust violations. Why antitrust violations? What they're saying now is the agreement, buyer representation agreements that have become common practice and are required by NAR as a result of the settlement, essentially can require that buyers be bound to being represented by certain agents for undue periods of time, despite poor representation, and essentially locking a buyer in with a terrible agent or for too much money for too long a period of time, and that restricts competition and therefore is anti-competitive. Here's the thing. The Department of Justice is part of the executive branch of government. Obviously, we've just had an election. We've just had a change of party in the White House. And as a result of the election, that very same party controls both the House and the Senate and appointed a majority in the Supreme Court and appears to feel very differently from the prior Department of Justice under President Biden, where all of this kind of sped up. They also favor deregulation and kind of a laissez-faire or hands-off approach to commerce. Again, some regulation necessary. This is not even a political opinion, Ryan. This is not a political statement in any way. I just think I have a hard time putting a lot of stock in this opinion from a DOJ that may not be in place in 3 months. You know, concern is appropriate in this scenario. We just feel like we weathered a storm. Mm-hmm. You know, some generational change. Honestly, from where I sit, the industry is improved. I don't like still, and I think that we are at risk by disallowing sellers from marketing essentially a concession, which is the appropriate word to be using. Disallowing the sellers from marketing an offered concession to prospective buyers through the most widely distributed source of information, the MLS. I think that is detrimental to sellers. It seems like sellers have been kind of forgotten throughout all of this because of the facts of that rates are high temporarily. Rates are fluid. They're going to go up and come down and go up and come down again 1,000 times now and in the future. And prices are relatively high compared to earnings right now. So we have a lot of sympathy, and we've let our sympathy for buyers cloud our view of sellers. Sellers can be victims in this scenario, and not allowing them to market a concession, I think, puts them at a distinct disadvantage. I don't know why we have to do that. I've said it numerous times in this podcast. If we decouple commissions, which is, I think, needs to happen, has begun to happen, and will continue to happen. I'm on record with a lot of our agents here, and I'll do it here on the podcast. If our local association of realtors does not rewrite our listing contract that we sign with sellers in this next round of forms release that comes out in January, I am rewriting ours, and we will not use the local association of realtors listing contract. The commission paid to a buyer's agent by a seller is a concession. It's a concession from seller to buyer. It should be referenced that way. It should be split in the contract with the seller and the listing broker to say, I will pay you X to list and sell my property. I will offer a concession to the buyer of why they can use it as they please, but to include, but not limited to, pay their agent. The thing is, I'm going to rewrite it, and it's going to be written appropriately. I don't know why we're worried about what the DOJ thinks in the next 3 months or 2 months or month, because it's all subject to change potentially. I do agree with the DOJ's assessment that some buyer agreements are anti-competitive, but we can go after individual bad actors easily enough that we don't have to punish the entire industry, because right now our clients are better informed. Our buyer clients are better informed because they're signing a contract with us up front that says that they completely understand what we're being paid and how we're being compensated. And there's no room for error there. So I don't think you can assume the entire industry is bad actors. And I think that's what the DOJ is doing.